Good afternoon, and welcome to DBIA's Design Build Done Right webinar series, and today's webinar, Understanding the New DBIA Code of Conduct. Before we begin, there are a few housekeeping items. If you have a technical support question, please type it into the chat box. If you have a question for the speakers, please type it into the question box. A PDF version of the presentation is available under the Resources tab. Now, for today's speakers, Jimmy Barber, PE, Lead AP, DBIA, and Tom Porter, JD, DBIA. Jimmy Barber has been performing electrical engineering for over 40 years and has a wide range of experience, including multiple overseas assignments. He has been with the Haskell Company for 35 years, is a Design Build Institute of America designated professional, and a LEED accredited professional. Jimmy was prior chair of the DBIA Certification Board, has served as chair of the Florida region of DBIA, and has served on several committees on behalf of DBIA, both locally and nationally. Tom Porter is currently vice president at Barton Malow, a $2.5 billion construction services firm based in Michigan, where he handles various executive functions, including safety and workforce engagement. He holds the DBIA certification and served as DBIA's 2009 national chairman. Tom is the author of Profit, Risk, and Leadership, The Business of Construction and Design Build, published in 2012. Now please join me in welcoming Jimmy Barber and Tom Porter.
Hello, everyone. This is Jimmy Barber. I'd like to thank everyone that's joined us. It's an excellent turnout today, and we're really pleased to hear that and see that. Let me thank the other members of the task committee. You've heard about Tom and myself. We also have Pat Miller, who's an attorney in private practice with Faugre Baker Daniels out of the Midwest. We have Jeff Gagne, who's a PE and vice president with HNTB out of the transportation sector and works in the Southeast. We also had a thought leader who was the former chair of the DBIA organization, and he's an attorney and the senior vice president for Burns & McDonnell, who's a large design builder out of the Midwest. And also a resource was Venable as a law firm that handles these type of organizations, was engaged to review our documents and help us out. The big question on something like this that we've undertaken is why would we do this? The reasons are DBIA is committed to continuous improvement. DBIA is dedicated to the highest ethical standards of professionalism, integrity, and competence. The guidelines in this Code of Professional Conduct, we feel, fulfill those obligations. Also, as a DBIA credential holder, I feel you are ethical and conduct yourself professionally, and therefore all of your compatriots should be doing the same. The importance of this is that professionals throughout this document and this webinar we're presenting are defined as credential holders, who are our DBIA professionals and our associate DBIA professionals. So keep that in mind whenever we say the word professionals. The other thing that's happened as the DBIA has grown, the DBIA certification process has grown, and it's grown exponentially, in fact, with over 3,000 professionals right now. Our DBIA leaders and members determined it's time to elevate the DBIA professionalism and update the Code of Professional Conduct. Tom will go through the sections 1 and 2 of the code regarding the introduction and the ethical rules and comment. Tom?
Very good. Thank you, Jimmy. So we begin here with the code introduction, and I think a copy of the code is available online at the DBIA site, and I think it may also be in our resource item here. But I'll be going through and talking about some of the key provisions in the code itself, in the introduction, and in the ethical rules and comments. So the introduction to the code begins with the concept that the code is very important to our industry because we're expecting designated design build professionals including associate designated professionals, to set the example and to demonstrate the highest standards of ethics for our industry. There was a fair amount of discussion when the code was being put together about would the code apply by its terms to only the designated professionals, or would it apply beyond that? And the decision that was made and adopted by DBIA was to have the binding rules and enforcement apply only to the designated professionals and to the associate designated professionals. The thinking being that DBIA specifically reviews the qualifications of these individuals and through the certification board grants that designation status or associate designation status, and that the organization should retain the authority to take that away if there are ethical violations that are brought to light. So, and yet we're hoping that in adopting this code, that the effect of the code is not limited to only the designated professionals and associate designees. We're hoping that the code also serves as guidance and maybe consider it an aspirational document for the benefit of everybody involved in the design build industry, even if those individuals are not themselves designated professionals or associate designees. But again, only the designated professionals and associate designees are bound by the rules of the code. I also need to talk about the difference between ethical rules and comments. So in drafting the code, Jimmy and myself and a group that worked on the drafting had some discussion on whether everything in the code is going to be binding or whether some things in the code are just for guidance and encouragement. And the way we handled that was to say that we would have a series of rules, numbered rules, and the rules themselves would be binding on the designated professionals and therefore be a basis for disciplinary action and enforcement. However, there are, following each section of rules, there's a section of correlated comments, and the comments are not a basis for enforcement. The comments are just to provide additional guidance, maybe clarification of something that's in the rule, and maybe it goes beyond the rule and provides aspirational objective and encouragement to the industry to do something that we're not ready to make it a basis for enforcement, but we'd like to encourage people to take a higher standard. And so those are sometimes the purpose of the comments. We'll be talking about some of the comments as we go through the documents today. So before I plunge into the code itself and the first section of rules, I'm reminded of the story about the senior partner of a law firm. And being a lawyer myself, I have license to tell this story. So the senior partner spoke to a meeting of his colleagues and says to his partners, we really need to draw the line on ethical conduct. However, he went on to clarify it and say, let's draw that line with an Etch-a-Sketch and not be afraid to shake it a bit from time to time. So, again, we can poke a little fun at the legal profession, of which I am a member, and yet, hopefully, when it comes to the DBIA code and how it applies to designated professionals and how it applies to associate designees, I hope we have a little bit clearer of a line than the one in that law firm example. So let's turn then to review of the code itself. There are numbered sections, 1 through 9, and subparts. And so we begin with Section 1, which has general duties. And it begins in Rule 1.1. We're not going to touch on every rule, but we'll hit the highlights here. In the very first rule, it begins by saying professionals will not knowingly violate the law. So that it basically is saying that as a starting point for ethics, not the end point, but as a starting point, those bound by the code are expected to follow the laws. And the rules go on to say that apart from following the laws themselves, designated professionals are not supposed to assist others to violate the law if they know that that's what's going on. In addition, there is a rule specific to those who are licensed professionals. So if someone is a professional engineer or a professional architect or a professional attorney, for example, in a licensed profession, then the rules and requirements applicable to that licensed profession shall be followed, and if they're not followed, that becomes a basis for violation of this code as well as violating the licensing requirements of the underlying profession. So then we move on to our comments on Section 1 of the code on the general duties. So the comments have some of the aspirational language that I referred to. It encourages all professionals, and frankly everyone in the industry, to be leaders of character and honor, to honor their words and follow through appropriately with their actions. The comments also talk about the situation, what happens when there is litigation pending in a court or other tribunal concurrently with an issue involving a DBIA rule or violation. The expectation is that the court would go first, that if there's a criminal action alleging criminal fraud, for example, that DBIA would look to the courts to resolve that issue first and reach a conclusion prior to DBIA taking up the cause and dealing with ethical enforcement consequences. The comments also clarify that we're not really trying to get into immaterial minor violations here. A routine traffic ticket is not supposed to be the kind of thing that gets somebody's designated professional status revoked. And it's also stated in the comments that the professionals are expected to be able to rely on other qualified persons. That could be a lawyer, it could be a design consultant, for example, or someone with knowledge or expertise helping them to comply with the law. There are some additional aspirational goals. Some that I'll mention here are that professionals and others observing the code should try to avoid associating in business ventures with persons or firms if they believe those persons or firms are involved in fraudulent or dishonest conduct. And then the final comment under Section 1 talks about what happens in the event of reporting. Our task group discussed whether failure to report a violation should itself be a violation. We did not make that decision. Instead, we said that in the comments, professionals and others are encouraged to promptly report when they become aware of a violation by someone else of the code. So those are the key points in Section 1 of the code. Going on to Section 2 deals with truthfulness. And you will find a reference to the importance of truthfulness in many places throughout this code. Of course, in part, it's already covered in Section 1, where there are laws requiring honesty and anti-fraud regulations. But we have a section specifically on truthfulness, Section 2. Rule 2.1 says that professionals shall act honestly and will not engage in fraud and will not deliberately make false or misleading statements of material fact. So a key blanket honesty and anti-fraud provision is right there in 2.1. Rule 2.2 goes on to give a little bit more specifics and say that when design build professionals are pursuing a project or working on a project or applying for membership to the organization or applying for a professional license, those are areas in particular when the professionals are expected to honor the requirement of truthfulness and refrain from any false, fraudulent, or misleading statement. And the comments to Section 2 reinforce the importance of truthfulness as a key principle in the code. So let's continue then on to Section 3 of the code, conflicts of interest. Here, Rule 3.1 defines the general requirement on conflicts of interest and says that if there is a material conflict of interest relating to design-build services, the professionals have to disclose it promptly and then take appropriate action. Appropriate action is going to depend a lot on the circumstances, but the rule gives some examples. It may include obtaining written consent. If the clients give informed consent and they say, well, we've been made aware of the conflict and we're not concerned, that could be an acceptable way to resolve it. And in some cases, however, the acceptable course would be for the professional to withdraw from the engagement. So the rule does not give exact details about when one course of action is required versus another, but tries to leave that to the judgment of the professional. But again, that is subject to review in a disciplinary proceeding. Rule 3.2 talks about a special situation in which a professional is acting as a neutral decision maker. Sometimes professionals are advocates for a particular position or point in a project, but other times they're being asked to serve as truly neutral decision makers. An example would be if a design-build professional is giving an evaluation of another party's performance, say in the preparation of a punch list, or approving or rejecting work, or approving submittals, or certifying pay applications. And of course, there are situations in which design-build professionals will be asked to render decisions or either advisory or binding decisions on claims that are made by other parties. In each of these contexts where the professional is acting as a neutral decision maker, then the rule requires the professional to act in a neutral, impartial manner. Continuing on, Rule 3.3 talks about public statements by professionals, and Rule 3.4 is a similar concept. When you read those rules together, they basically say that if a professional is being used as a hired gun, then the professional ought to disclose that. So, for example, if a professional is making public statements about the desirability of a certain technology, if an architect, as a design-build professional, is saying, you really ought to use this new cladding system for your building, and this is an outstanding cladding system, if the architect is getting paid to be a spokesman on that, the point ought to be disclosed. And again, if the architect is specifying a particular system and is getting paid to do that, then the financial arrangement ought to be disclosed and not concealed. The comments in Section 3 talk about how you figure out what's a material conflict of interest. You can look at the governing law, and beyond that, you can look at whether the professional's judgment is likely to be affected by the conflict that presents itself. And then there are additional comments. In comment 3C says that professionals should be open and honest in their contract relationships and disclose openly situations that could lead to a conflict of interest. Again, that's not a rule that has disciplinary teeth associated with it, but it's an aspirational goal to anticipate possible conflicts and let the client know ahead of time. That brings us to Section 4, influencing the decision makers. So here we could oversimplify and talk about bribery as a shorthand heading for Section 4. And needless to say, bribery is something that's not tolerated by this code of conduct. Rule 4.1 says you cannot make a payment. Professionals will not make a payment or a gift, whether it's private or public, if it's the intent of influencing that person's judgment in connection with a project. in which the professional has an interest. So that would be kind of a classic definition of bribery in some ways, and the professionals, of course, are not allowed to do that, and that's prohibited by this code. By the same token, professionals aren't supposed to be on the receiving end of those kind of payments or gifts. And so if it's a payment or gift to influence a professional's judgment in a professional matter, then that should be refused. Again, that has disciplinary consequences. The comments go on to clarify in comment 4A that normal legal campaign contributions are not considered a violation. If it's within the legally restricted limits and not for the improper purposes that we've talked about, then a campaign contribution is not prohibited by these rules. And similarly, depending on the context, it may be common to have business entertaining or hospitality go on, particularly in a private market setting. And so in those settings, if the hospitality or entertainment is normal and customary and not intended to have an undue influence on the judgment of an official making a decision, then that's not intended to be prohibited by this code. Comment 4B talks about a situation where a private company, for example, may have a policy. And so if you're dealing with a large manufacturing company, perhaps they have a policy and say that we are not allowing any gifts or any sports event tickets or concert tickets or golf outings to be accepted entertainment for our procurement people. If the company has such a policy, professionals are really encouraged to follow and honor those policies. So that brings us to the end of Section 4, and we continue on to Section 5, where we talk about the marketing and project pursuit. Again, in a way, we've already covered this because we said in Section 1 that you're not allowed to commit fraud, and we said in Section 2 that you need to be truthful. And those are the key principles that come into play when it comes to marketing and project pursuit. But we make it a little bit more specific in the rules under Section 5. In Rule 5.1, we say if you're chasing a project, professionals should accurately represent their qualifications, their capabilities, and their experience. And that has, if it's misstated in a material way, that has disciplinary consequences. Rule 5.2 goes on to say that if a professional or professional organization is publishing materials, they should not intentionally mislead clients, or they shouldn't, and this is also covered in 5.3. You shouldn't mislead clients about the results that they're going to get. You shouldn't promise that design build is going to get their job completed twice as fast if that's not supportable by the real evidence and the facts of the circumstances. And similarly, in your brochures, in your proposals, in your marketing materials, it's important that those be honest and ethical, and professionals are expected to honor those requirements for truthfulness. So in the comments for Section 5, we talk about the situation that arises. What if a design build professional is going to pursue work that the design build professional hasn't done before? Is it fraudulent or false or a violation of the rules for the design build professional to say, I can do this office building project for you if the professional hasn't done that kind of office building project before? We're not saying that that's false or fraudulent because you have to get started somewhere, but the communications ought to be honest in indicating the real qualifications of the professional. They ought to be honest in indicating how the professional is coming up with the ability to do that. Are they coming up with the ability through added study and education, through engaging consultants or other teammates, perhaps, who have the necessary expertise? Comment 5C says that in the competitive procurement process, professionals should always compete fairly. And then comment 5D talks about the situation of what happens when a firm is giving their credentials in response to a request for qualifications, and they talk about a prior project in which the firm had a limited role, and other parties, suppose the contractor says, well, we get all the credit for the Acme job, but should they also give credit to their joint venture partner? Or should they also give credit to the design team and other key participants in that project? That is recommended to be fair about doling out the credit for prior engagements. We move on to Section 6 of the rules. In Section 6, we talk about procurement. And just as the rules of this code apply to professionals acting as design builders, in a similar fashion, they also apply when the professionals are acting as owners on the procurement side. So if the owner's procurement is being done by a designated professional, it's expected that professional will conduct the bidding and procurement honestly and with fair dealing. Or if a prime contractor's professional personnel are doing it, they should act honestly and with fair dealing. Rule 6.2 is specific as to price fixing and bid rigging, which are prohibited by law and prohibited by these rules as well. And then 6.3, Rule 6.3 deals with a situation where a professional is a member of a selection committee, voting or recommending member. The rule says you shall not participate as a member of one of the competing teams if you're on the selection committee. At least, you would at a minimum have to give proper disclosure and notification to the affected parties if that unusual arrangement were to happen. Rule 6.4 says you shall not be on the selection committee if you're involved in the project in some other way. And again, and Rule 6.5 talks about confidential information. If the selection committee gets confidential ideas from one team member, from one team competing for a project, then there has to be ethical behavior in how that information is treated. It's not normally appropriate to share confidential information received from one competing team with the other competing teams, at least unless there is a specific RFP provision that addresses that and puts everybody on fair notice. We move on then to the comments for Section 6 procurement. There's a few I want to mention. That if the criteria for the selection are spelled out by law or spelled out in the solicitation documents, then the professional should follow those criteria. And that's in comment 6B. And in 6E, we say that, again, if you're acting as a consultant assisting an owner, you normally shouldn't be one of the competitors on one of the design-build teams unless it's legally allowed and you've given fair notice to everybody involved. Rule 6F deals with the situation of bait and switch and says that you should, if you need to make a replacement on your team, you should make sure you're replacing it with somebody with equivalent capabilities. And in 6G, if you're evaluating a technical submission in the design-build process, you should try to keep the evaluation of technical merit separate from the evaluation of cost and not let the one bleed over into the other. We move now into Section 7, Project Administration and Execution. 7.1 is an important rule that says professionals have to be competent and they have to carry out their duties in a competent manner. Rule 7.2 says professionals shouldn't alter the scope or the objectives of what they're doing without knowledge and consent of the client. And 7.3 comes back to this concept of truthfulness. The professional shouldn't distort or misrepresent quality, level of completion, or similar information. The comments to Section 7 say that it's important for professionals to try to uphold the advantages of design build. We do design build because we hope it'll create benefits in schedule, in price, in collaboration, in innovation. And if you're a design build professional, you should make sure that the way you carry out design build tries to serve those purposes for the client's benefit. Comment 7B says that you should comply as best you can with the payment requirements of your contracts and applicable law. While we are not attaching discipline to this particular comment, it's not a rule, it's just a comment, but it's an important concept, not just the same. The parties should try to comply with those payment obligations. Moving on to Section 8, deals with the very important topic of health and safety. Design build professionals must refrain from conduct that jeopardizes safety or health of any persons or the public. That if you're an architect or an engineer, that's part of your professional licensing commitment to protect the public and the public interest in the way that you're designing facilities. And that carries through into the design build arena here. Rule 8.2 says what happens if you become aware of somebody else on your team or your employer violating applicable law, particularly in the health and safety arena. In that situation, you may have a duty to do more than remain silent. 8.2 says if there's health issues at stake, you may need to advise against the conduct, refuse to consent, and ultimately you may have a responsibility to report. And then we move to Section 9, the last section of the rules and comments, which deals with confidentiality and intellectual property. Rule 9.1 says professionals need to uphold the confidentiality of the procurement process where that's called for. And Rule 9.2 says that professionals will not use unique ideas or other intellectual property that's provided by a team without appropriate consent and approval. And Rule 9.3 says professionals won't disclose the proprietary information when that's contrary to the principles here. In the comments to Section 9, we say that if there's a legal obligation to disclose confidential information, then that prevails, of course, over the code. So that's a quick overview and summary of the operative provisions of the code, the rules which have enforcement, the comments which are for added clarification, and hopefully that's a helpful introduction. Although we didn't cover every rule, I tried to hit the high points and the key principles that are informing these rules. With that, I'm going to turn it back to Jimmy to talk about the complaint process and the discipline process.
Thank you, Tom. I'll go through this part of the code in a highlight manner also, and then try to allow maximum amount of time for questions at the end. The Part 3 of the Code of Professional Conduct covers the enforcement and disciplinary actions, and the basis for complaints is all hinged around the grounds for disciplinary action. So if you have gross negligence, willful misconduct, conviction of a professional for a felony, or you have fraud and deliberate misrepresentation of the DBIA membership or designation, those we feel are the grounds for disciplinary action. So those become the basis for complaints and become part of the violation of a rule. And like Tom said earlier, the rules are what we would look for complaints on. The comments are just there for aspirational goals. If you have a violation, it has to be by a professional, either a DBIA professional or an associate DBIA professional, because we don't cover the general membership in these enforcement activities. I'll talk a little bit about that later, why we set it up that way. Like I said before, if you're professional and you have a felony conviction, we will be subject for taking a complaint on that. And then the fraud or deliberate misrepresentation of DBIA membership is something that we're guarding closely. We want to ensure that our credentials are at the highest level. The procedure for complaints is spelled out in Part 3. The procedure is very detailed, and the reason we did that, it takes 4 pages to explain it all. The reason we did that is the recommendations of other societies and our legal counsel that works with those societies is that the complaint procedure must be very detailed and very thought out and listed that way. The idea being we don't want any challenges to our procedures or disciplinary actions or what we do. We want to be robust and have a very clear understanding of how things apply to people when they do have a complaint or an appeal. So the procedure for complaints, the highlights are that the complaint must be in writing. Those have to be signed by the complainant. The forms are going to be on the DBIA website, and Mahisha will tell you about that later. And how to file them is also in the document. That then would trigger a review of the complaint and a possible determination of violation. Then, based on the violation, we could have different types of disciplinary action: written admonition, suspension of that DBIA professional or associate DBIA professional certification, or we could have permanent revocation of the DBIA certification. The concept here is that the DBIA certification board gives those designated professional certifications. Therefore, they can also revoke them or take them back or put them on suspension. We do have an appeals process. Once again, this was recommended that we have a way to let complainants come back and appeal something that goes on if we do have an enforcement or disciplinary action. And the basis for that is that a professional can appeal the decision. The complainant can also appeal the decision. But there's no new evidence that can be presented. It just goes back to the evidence that was gathered in the original review. The procedure for the appeals is lengthy, but it's very detailed again because we want to make sure that nobody can challenge us on how we've done that. So the appeal must be in writing. The appeal must be submitted within 15 days receipt of the certification board decision. That was the decision about the disciplinary action. And once again, the forms are on the DBIA website, and how to file is in that document. This would trigger an appeal committee being formed, which is different than the review committee that looks at the complaints and the disciplinary actions. Those are reviewed, and the appeals actions can be either approval and implementation of the certification board decision that was already promulgated, or there could be a modification of the certification board decision, or it can be remanded back to the certification board for further action. All these are triggered by the committee that does the appeal, and it's run by the DBIA National Board, not the certification board. So we have some checks and balances in there. Notifications. When we do have a disciplinary action, we're not going to publish that information. We're going to notify the professional, notify the subcommittee members, notify the members of the certification board and the national board. Obviously, the executive director of DBIA will be notified and the complainant. All these people will be notified, but we will not publish them. That was a decision made to keep that among ourselves. The surrender provision is in place so that a professional can surrender their certification anytime during the complaint process, and then the complaint is thereby dismissed. So we have that in there. This is, once again, a recommendation of what we've seen in other societies that have similar certifications. There is a reinstatement provision that the professional can reapply for certification after the suspension period. We talk about that in the document. I won't go into detail there. And then the question comes up, should members be covered rather than just the professionals? DBIA is comprised of both professionals and members. So it is possible that a person can be a DBIA registered professional and not be a member, and certainly the other way around. We talked about this, and we said for now we're not going to cover our members on the Code of Ethics, Code of Standards of Professional Conduct. The reasons for that is there's no standards now for becoming a member. DBIA is not endorsing the members. We also don't want to deter membership for any reason. And there's limited effective disciplinary consequences, mainly taking away somebody's membership. So another factor was we have DBIA firms that are members and are members in a industry category status, and then we have all the other people that are members as individuals. We didn't want to muddy it up, if you will, with somebody that gets enforcement or discipline regarding their individual status and what does it do to their firm status. So therefore, we haven't let the members be covered under this Code of Professional Conduct. So Mahisha will tell you the next steps, and we'll take questions after that.
So some next steps. The Code of Conduct will be officially adopted and effective as of June 1st. There'll be no impact to members only. However, credential holders, meaning our DBIA professionals and our associate professionals, will have to acknowledge receipt of an agreement to the code. Our existing credential holders will need to accept the code during their next certification renewal. For the new credential applicants, the Code of Conduct agreement will become part of the certification application. In addition to the code being included in the certification application beginning on June 1, all attendees of the DBIA trainings and workshops will be provided with a copy of the code as well. Also, DBIA National is working to incorporate the Code of Conduct into our educational curriculum as well as our certification exam. And lastly, after its adoption, the DBIA National Board and the DBIA Certification Board will begin reviewing the Code of Conduct on an annual basis to assess the need for any changes or updates. So now that we've discussed the upcoming next steps, we'd like to open up to some questions. And it looks like we actually already have a couple of questions. So question number 1, to your knowledge, are there any states or territories which incorporate DBIA Code of Conduct in state regulations? And then in parentheses, which is frequent for PE and registered architects.
So, answer to this question, to our knowledge, there are not any states. I'm not aware of any states or territories that incorporate this. Of course, this code is new, as we've just discussed, and so there hasn't been really, I doubt that the states or territories have had a chance to think about that. There was a pre-existing code, a DBIA code, that goes back many years. It was much more short, abbreviated, and sort of higher level concept. I'm not aware that the prior code was incorporated in any state regulations. I'm going to add a point here in response to this question. We do have a statement in the introduction to the code that reads as follows: nothing in this code is intended to raise the legal standard of care of any person or entity above that which is established by law. So by adopting this code, it's really a discussion between the DBIA and its designated professionals. We're not really trying to change the outcome of legal proceedings, enforcement proceedings, liability claims. That's not the intent. And so our hope is that this is a basis for designated professionals to understand what's expected of them to earn and retain that designated status.
So the next question, to your knowledge, are there any clients who have incorporated or referred to the DBIA Code of Conduct in procurement or contract docs? And then part 2 of that, Is there any reference or incorporation in the DBIA standard contract documents?
We have not seen anyone that's incorporated the professional code of conduct, either in the earlier version, which was a one-page version, or this present version we just issued. The thing that happens is it'll take time for it to be absorbed into the system, like Mahisha was telling you about the deadlines of dates for incorporating it. I don't think there's any reference at this time in the DBIA standard contracts to refer back to this code of conduct. The one thing I would say is there are government agencies and private agencies now that are asking for people on the design build team to be design build certified professionals. And almost by default, those professionals, once they accept this code of professional conduct, it becomes part of their daily duties, if you will. Anything else, Tom?
No, I think that's good. I think that covers the point well. So we are looking for additional questions. We have some additional time, but I think those are the only questions that I've seen come through so far. If you have other questions, please submit them now, and we'll do our best to answer. I know that Jimmy and I worked with our task group for quite a period of time, trying to tackle the questions and trying to develop an approach to the code that would make sense. We looked at a lot of other reference materials, codes for other professionals and other organizations, and hopefully this is a code that will stand us at DBIA in good stead and make sense to people. There were some areas of controversy along the way that Jimmy's alluded to that had to be resolved. Would we cover professionals, or would we cover a broader set of people? Would we have, would we have, how do we handle aspirational versus disciplinary rules? So we've worked through these, and if you have questions later on, please don't hesitate to bring them to DBIA, and if it makes sense, Mahisha or others at DBIA staff can reach out to Jimmy and myself and get further input, because we're hoping that this is broadly accepted by the design build community and helpful to our industry, helpful to our mutual profession. Jimmy, you have any other added comments? I'm not seeing other questions come through the system.
I would just thank everybody that's taken the time to attend the webinar and taking the time to look at the documents. It's a lot to absorb, and there's a lot of language in there that you have to go back and kind of read a sentence twice, especially when it comes to the enforcement paragraphs. But I think overall we are proud of what we put together, and we had a lot of legal representation on the committee to help us along. This document keeps going, and it will be looked at over time and see where we might need to tweak it somewhere along the way. And it's our document. It's all of our document. It's not just mine and Tom's. So let's continue on, and we'll look forward to any and all feedback.
Very good. I have nothing further. Mahisha, do you want to wrap up?
Sure. First, of course, thank you to each attendee for joining us for today's webinar, and a special thanks to our speakers, Jimmy Barber and Tom Porter. Please note that you will be directed to an evaluation directly following this presentation. Please complete the evaluation in order to receive your continuing education certificate of completion. This presentation will also be archived and available within the next few days. Please feel free to share this information with colleagues that were not able to make today's live webinar. Lastly, please visit dbia.org for a listing of upcoming DBIA webinars and educational opportunities. Thank you guys again, and have a great day.